Well, many thanks again for joining us tonight. And we'll begin with the Supreme Court, which has temporarily halted the move by the federal government to ban the use of the old naira notes from February the 10th. A 7-member panel suspended the move in a ruling in an ex parte application brought by 3 northern states of Kaduna, Kogi and Zamfara. The 3 states had argued that the note swap plan was causing hardship before the elections. But Judge John Inyang Okoro said the decision to suspend the deadline was unanimous. Nigerians were due to turn in old 1,500 and 200 naira notes in exchange for newly designed notes by Friday. The plan has caused controversy, with people saying there are not yet enough new notes in circulation.
We invoked the original jurisdiction of Supreme Court when there's a dispute between the state government and federal government. It's one of the few occasions where Supreme Court has the original jurisdiction. So we invoked the powers of this Supreme Court to hear this application. The reason for it is that as well-intentioned as this policy of federal government of the design is working hardship all over the country. As we can all see, banks are being harassed, Nigerians are suffering needless, especially the downtrodden. Those in the urban areas, they're having problems, but it's more excruciating at the rural area. So these 3 state governments, Kaduna, Zamfara and Kogi, deem it fit for us to invoke the powers of Supreme Court to intervene.
The other is an ex parte, and because of the urgency and the affidavit of urgency filed by the applicants, the court in its wisdom decided that something must be done because of the urgency. But the court has rightly, in its own wisdom, directed that all processes must be there by 15th, that is Wednesday next week, for us to argue our various positions.
And we're now being joined by King's Counsel and Senior Advocate of Nigeria, Fidelis Oditah. Well, he is in Lagos. Thank you, Senior Advocate, for joining us tonight on the program. Well, it's been an interesting day, you must agree. Or you can even say the last 48 hours as it concerns the Supreme Court of Nigeria. But let's talk about this ruling today. Neither the CBN nor the commercial banks were actually party to that suit that was filed by the 3 APC governors. So the question for you this evening is, how does this ruling affect them then?
Yes, thank you, Amaka. As you know, and as you've highlighted in the intro, the ruling was based on the exercise of the Supreme Court's original jurisdiction. And by original, I mean first instance, because normally the Supreme Court is a final court of appeal and doesn't normally exercise first instance or original jurisdiction, which belongs to the high courts of various states and in some cases the magistrate courts. So the reason I think that the section 3232 of the Constitution was invoked by the 3 states that went to court is precisely to ensure that the matter comes very quickly. Because if the central bank or the commercial banks had been joined, the Supreme Court will not have original jurisdiction. They would then be forced to start at the High Court, and before they get to the Supreme Court, the elections probably would have been over. So that's the reason they went to the Supreme Court, using or invoking the original jurisdiction of the Supreme Court. Now, the question you asked is whether the central bank is bound. As a practical matter, probably not. Because in theory, you would say a person who is not a party to a legal proceedings is not bound by a restraining injunction. But in the present context, one has to bear in mind that the power to redesign naira as legal tender derives from section 20 subsection 3 of the Central Bank of Nigeria Act, and that section gives the central bank power to redesign the naira only if directed by the president. So the central bank has no independent power on its own to redesign the naira unless the president directs. And I suppose in the present case where the president, through his attorney general, has been restrained, the president will communicate the restraints to the central bank. And therefore, in that sort of indirect way, the central bank will have to comply. And I believe that that is also perhaps why there was a meeting today between the president, the attorney general, and the governor of the central bank, notwithstanding that the central bank was not a party to these proceedings.
Thank you for laying the ground for the powers of the Supreme Court, the appellate and original jurisdiction, because some have raised the question about the independence of the CBN. As we know, this redesign of the naira policy emanated from the CBN, and so one will wonder in that regard, where is the dispute between the federal government and the 3 state governments that went to the Supreme Court, making it to invoke the powers of the Supreme Court?
I mean, that is a very interesting question. I heard you, yes. The section 232, which is the original jurisdiction of the Supreme Court, gives that court the power to hear disputes between the federal government and the state on any question of legal rights. Now, you have to ask yourself, what legal rights of a state government is involved? I read the affidavit of Aisha Diko in support of the application for injunction. And all she says is that it has caused hardship to the good people of Kaduna State. But with all due respect to her, that is a very nebulous proposition. You'd have thought that the various kidnappings have caused more hardship to various state governments, but none of them invoked Section 232. More importantly, over the past 8 years, the APC-led government has inflicted untold hardship on the good people of Nigeria. Not a single state government has gone to court to challenge the federal government or to challenge President Buhari why he has decided to inflict such a mitigated hardship on the good people of Nigeria. Even perhaps more important is the fact that this federal government and the CBN have completely devalued our naira-denominated assets. When they came to power, naira was 200 to 1. At some point, it got to 800 to 1 against the dollar. And the result of that is that the bag of rice, which was 8,000 or thereabout, when this APC federal government and the state governments came to power, now sells for about 50,000 naira. I did not see a single state government that went to court to protect the good citizens of the state and the good citizens of the Federal Republic of Nigeria from the hardship which they have been inflicting on all of us. It is even very cynical to see that of all the state governments, it is 3 APC state governments that have gone to the court to challenge the APC federal government. That tells you that there is something a little sinister in the case which was brought to the Supreme Court. It looks like it's just a ploy for politicians to have their way, to amass naira and to bribe the electorate. Otherwise, it doesn't make any sense at all. A lot of the hardship has already been felt, and in a matter of days, I think things are beginning to ease off. And in any event, the state governments, the last time I checked, did not pay whether pensions or current salaries by cash. All the payments they made were by transfer. So I don't see where their rights have been impacted. And I don't see why they should cry more than the bereaved. They claim that the good people of Kaduna State are bereaved because untold hardship is imposed on them. But this is the government crying more than the bereaved. Where they should intervene, they did not intervene. On the contrary, they have contributed to the to the hardship which has afflicted all of us. And instead of addressing those fundamental issues of insecurity, non-performing economy, social malaise, and other difficulties, they've gone to court to challenge the extension, the expiry of the denomination of the naira. That's just a disgrace.
Well, senior advocates, at the end of the day, some would say a lot of Nigerians are suffering as it stands right now, going by, all of what we're seeing at the ATM machines and even inside the banks. It's a crazy situation out there. But you know what? We're here talking about this ruling that came out today. And as a senior advocate of Nigeria, I want to ask you directly, if you were, for let's say, the lawyers to the federal government or probably the Attorney General of the Federation, how would you be handling this right now? What are the options really available to the federal government with this ruling today? And married out with what does this ruling really, how does it really affect that deadline of the 10th of February, which is barely 2 days away?
Thank you, Amaka. As a practical matter, the ruling is not going to have any effect. If you go to any market tomorrow and tender your old notes to any trader, the trader is not going to accept it, no matter how many times you cite this interim injunction. That is for a fact. If you want to try it, when you leave the studio tonight, try calling an Uber or Bolt. Offer them your old naira notes and tell them that the Supreme Court has said it continues to be legal tender at least until 15th of February. No one is going to pay you any attention. So as a practical matter, the decision is not likely to have any effect on those supposedly that it was intended to relieve. At a legal level, or as a matter of legal substance, it is very difficult to see how the policy can be challenged. The section which is invoked by the states is section 20 subsection 3 of the CBN Act, which gives power to the CBN subject to directive of the federal government to redesign the notes provided they give reasonable notice. In the present case, notice of the withdrawal of the naira was given on the 26th of October 2022. The central bank therefore gave 3 months notice, or just over 3 months notice. You might say 3.5 months notice. The question is 3.5 months notice reasonable notice within the meaning of section 20 subsection 3? And who is it to determine what is reasonable notice for this purpose? We can start from the basic premise that the question whether or not any notice, whether it is 2 months, 2 days, 6 years, 2 years, is reasonable or not in the context of section 20 subsection 3 is a question of fact and degree. So there is no absolute criterion by reference to which the reasonableness can be measured. The mere fact that people are suffering hardship by itself is not indicative of the unreasonableness of a notice. The hardship might have been caused by the banks, the fraudulent banks, which instead of providing the notes have decided to sell the notes to POS merchants and to politicians. That does not mean that 3 months is not a reasonable notice. If you ask me as a person, not as a lawyer, do I think that 3 months is enough to withdraw the naira notes given the cash nature of this economy? I would say, well, it depends. It depends.
Time. There's a second leg to Amaka's question. The advice or your decision if you were the Attorney General of the Federation or counsel to the federal government, what would you do?
If I were the Attorney General, I would advise the federal government to obey the directive of the Supreme Court, which says that the matter is reserved to the 15th of April. I beg your pardon, to the 15th of February. It says the federal government should not implement the expiry by the 10th, and they should direct the central bank and the commercial banks to do so. But it did not say when the notice should expire. And I suppose, in a practical sense, if I were the Attorney General, I would tell the federal government, the President, and the central bank governor that as a law-abiding government, we should obey the central bank, I beg your pardon, the Supreme Court decision. But how do we then implement that practically? We have to await the court on the 15th, because you have to remember that the central bank said two things. First, they said they were going to give 7 days grace period after the 10th, so which would take their own period to 17th of February. In addition to that, the central bank also said even after the 17th of February, they will continue to receive old notes through their various branches and channels. And therefore, the 10th or the 17th of February was not an absolute drop-dead date. Does the Supreme Court have power to direct the central bank to make the old notes legal tender after a particular period. I doubt it, because the power to determine what is legal tender is vested in the central bank by Section 2 and Section 17 of the Central Bank Act. And I do not think that that is subject to any direction of the president.
All right.
And given that the central bank is not a party to these proceedings and the views of the central bank have not been canvassed, the implications of the court's ruling have not been taken into account, it is difficult to see how the ruling can be given a wider effect.
Thank you very much, Senior Advocate of Nigeria and King's Counsel, Fidelis Oditah, for shedding more light on this ruling. We do appreciate it.